Well, good morning. As she said, Major Goines. So I teach cyber law. I've got my master's in cyber law and space law, and I teach at the Air Force Academy. Today we're talking about cybersecurity duties. Quick caveats before. The first is, obviously, although I'm in uniform and I say my name's Major Goines, I'm not necessarily representing the views of the Department of Defense, the Air Force, or the United States of America. I don't think anything will conflict with department policy, but just in the event it does, there's the disclaimer. The second thing is that obviously none of this is legal advice. If you have a specific legal issue, I'd really encourage you to talk with either your legal advisor, your legal counsel, or actually get with an attorney who can give you specific legal advice for your particular issue. So, cybersecurity duties. We were asked to talk about these, and the reason why is it's not necessarily a surprise. It shouldn't come to a surprise to you, because a lot of people ask me, well, Major Goines, what requirements do I, as a cybersecurity expert or cybersecurity professional, have to comply with under the law? Unfortunately, I hear a lot of things, but I don't know how all of these laws work together, and there's a lot of, it's kind of a hodgepodge. It's not like we're in Europe and we've got the GDPR that tells us one law, centralized location, that tells us exactly what we need to comply with. We've got a bunch of different ones. And so my goal in this is to sort of provide you with the de facto, all of them, all-inclusive sources, so you know which ones that you have to comply with. And then from that point on, you can do some further research to figure out exactly what you think. And then hopefully parse through all of these and tell you what I think is the bottom line duty for you to comply with in order to comply with all of them. So why do we care about cybersecurity? Well, mainly money. And I mean money seriously, because it can cause a lot of different things. So for example, if you fail to comply, you might get prosecuted for a crime, you might have fines or civil penalties, you might have attorney's fees, adverse court judgments. So if you go and somebody sues you for a breach, it's possible that you could end up with a huge penalty. Damage to reputation. So for the example, if you think of yourself as like a Home Depot or a Target, right, with these big breaches, ultimately hurt their reputation. And then finally, loss of business. The people might not shop at Target anymore or in your small business as a result. All right, so here are the categories of cybersecurity laws, or the duties that the cybersecurity laws sort of impose. The first one is the duty to keep data secure. And I say 4 sources, and what I'm telling you is that there are 4 places you need to look in order to figure out what particular data security laws that you have to comply with, what duty you have. And what do we mean by data security? Well, data security is basically protecting the data, okay, before it's breached. When somebody gives you data, you have a duty to protect that data. And then if something happens to it, we have a duty to do something when the breach occurs, when somebody hacks into your system. Also 4 sources. You're going to find out that they're generally the same 4 sources. Finally, or third, I'm going to talk about cyber crimes, why these are important to you. There's going to be 2 reasons. We'll get to those in just a second. And then finally, Cybersecurity Act of 2015. It's a federal act that they passed, and we're going to see why that's relevant to you. Now, with that said, what we found, cybersecurity laws are sort of in their infancy. They're not necessarily well established yet. We don't have a ton of cases to rely on. We have some, I'll mention those, but we don't have a ton. And as a result, we're sort of starting to feel out what this stuff exactly is, and I'll do my best to give you what I think are guiding principles that you can follow. With that said, most states, we started out with data security, we started out with cybersecurity laws, we went straight with the duty to notify when a breach occurs. The concept was, well, we don't know exactly what data security should look like, and so as a result, most states just passed a breach notification. If we're worried about consumers, if we're worried about victims of potential identity theft, well then what we will do is notify them when their data had been breached and had been somehow received by an individual, and therefore that will protect them. We've started to see a trend over the last 5 years of states starting to pass data security requirements, as in now we're going to be thinking in advance. We're going to be looking at what you're doing, and we're going to tell you how you have to keep the data secure, because they thought this was enough to keep, sort of give this impetus to businesses to protect the data. And what they're realizing is it's not. And so Colorado just recently, so I've mentioned the first duty, the first source, is to keep data secure. Colorado recently passed a law that included now a data security component. Not all states have these. All 50 states do have a cybersecurity law of some sort. Most of them are just breach notification requirements. But now we're starting to see, so Colorado I think is the 14th state to pass a data security obligation. And it went into effect on September 1st. So if you keep information, if you are a covered entity, as we'll talk about in just a second, September 1st, you're supposed to comply with this particular duty. Who is covered? A covered entity. So it used to state a person or business or a company. Now it changed that to a covered entity. It becomes a technical term, which means it has a definition. It says anyone who maintains, owns, or licenses personal information, in quotes, we'll talk about that in just a second, in the course of their business, vocation, or occupation. So if you, at any point, maintain, own, or license information, collect it, personal information, you would qualify as a covered entity and must comply with this duty. What's personal information? Well, it's any information on a Colorado resident that falls into one of these categories. There's 3 categories. The first category is if I have your first name or first initial and your last name, okay, if I maintain that, along with a second piece of identifying information. So for example, your social security number or your military passport or student ID, if I've got that identification number, driver's license number, identification card number, medical information, your insurance identification number, or this catch-all biometric data. If you think about the goal of data security, it's to keep information secure such that an individual can't get it, perform identity theft, go out there and steal your identity. So what we're trying to do is maintain that information, secure that information that may provide them or equip them to go do that. So this is the first category that they say is important. They think that if I have your first name or first initial and last name plus one of these things, I now can go out and steal your identity. So what does biometric data mean? Well, the truth is it's not defined in the statute. And if you read biometric data all over the internet, there's various different definitions. What do they basically mean? I think what they mean is facial recognition, fingerprints, maybe blood type, DNA, et cetera, things that might allow you, because we're starting to turn, technology-wise, we're starting to turn to biometric data as ways to access information, access your account. And so if I have that biometric data coupled with your first name, first initial, and last name, I can probably start to do it. So that's the first category of types of information that you collect. Second one is username, email, plus a password or security question answers. Those are ORs, as in if I have the email plus the security question answers, I now am a covered entity. So if you have any information, if you have an account whatsoever for that person, like an online account, you're probably going to fall under this security, or under this covered entity. And the final one, the one that we probably all kind of suspected was coming, an account or credit or debit card number plus the security or access code or password. Right? So if I have that, then I would qualify. So if I'm a person who runs credit card numbers and I've got that security code on the back, in order to ensure that I can run it, online businesses, I comply with this, okay? Or I fall into this. Makes sense, yeah. All right, so it keeps going, right? So what is it, right? The Major Goines keep talking about this duty. What is my duty? So if I fall as a covered entity, I collect that information, and I have a specific duty now. What's that specific duty? Here it is. And the underlined part's the most important part, right? I have to implement and maintain reasonable security procedures and practices that are appropriate to the nature of the personal identifying information and the nature and the size of the business and operations. So what you see here is you see the word reasonable. Now, a lot of times people don't like that word, right? They think, well, reasonable doesn't really provide me enough to go off. I want specifics. I want somebody to tell me you have to employ this security protocol. If I employ this security protocol, thumbs up, I'm good, right? Well, there's a problem with that, right? Because technology constantly changes, security protocols are constantly compromised, and if we were to put a specific one in there, it would require Congress or the state legislature to work more than once a year. Just joking. That's a joke. It would require them to constantly update it. And so it doesn't make sense from that perspective, right, to put a specific one in there. The other thing is, and this is what my hacker students tell me, is if you put a specific one in there, what would I do? I would target that specific security protocol, and I would go after it. And I'd figure out the vulnerabilities, and now all of you out there who are trying to comply with this are now subject to potential exploitation, okay? So as a result, they put this in there, but I think we should rest easy a little bit because reasonableness is a nice sort of standard for the law. In the law, we use reasonableness quite often, right? So, for example, if you get in a car accident with somebody, usually the question is, did you act as a reasonable person would have in the same or similar circumstances? So reasonable isn't that bad. And if you think about it, it also puts in there this balancing test, right? It's got a balancing test at the latter part. We're going to balance the nature of the personal identification information, right? What kind are we dealing with? Is it something as simple as a username and password, or is it something as simple as a student ID plus their first and last name? And we're going to match that with the size of the business. So if the business is really small, the legislature sort of understands that you might not be equipped with all the resources necessary to employ a very robust cybersecurity protocol, right? And so as a result, they have this sort of balancing test in there, and I think we should, at one point, sort of take a little bit of ease, understanding that we're only going to be measured as a reasonableness standard. All right. The other thing that's interesting about this is that they say if you do decide to employ a third party, so you say I'm going to delegate and contract out my cybersecurity because I can't do it, you still have the obligation to ensure that that company is complying with this standard. So you don't get to necessarily just shove it off, forget about it, and walk away. With that said, I would recommend, and once again, not a lawyer, right? Or I am a lawyer, not your lawyer. I would recommend to you that you might want to consider within that contract creating what's called an indemnification clause, which basically says, in the event that it fails, you will indemnify me, you will pay my legal expenses that I would have to endure had you not breached your duty, okay? That'd be my recommendation. The other thing this sort of highlights to us is that because of the reasonableness standard, because there's no security protocol that they specifically state, it kind of puts the onus on us, right, the covered entities, to constantly maintain it, which means we can't just put it on the shelf, walk away from it, come back in 2 years. Rather, we have to go back and check and see how this cybersecurity, how it's sort of changed, what potential protocols have now been compromised, and how I can change my practices to be reasonable. So now it puts an onus on you to constantly, and by constantly I mean regularly, go check your cybersecurity protocol to make sure it's still reasonable, okay? Now, the second duty that it requires is that it requires you to maintain a written policy for the disposal and destruction of any PII that you actually have and you no longer need. With this, it sort of implies that you're going to actually have a duty to destroy once you no longer need it. Now, it doesn't say you have to destroy it. It just says you have to have a policy to destroy it. But I, as a lawyer, if I was a plaintiff's lawyer and I came out and said, oh, wait a minute, you had a policy but you didn't stick to it? Well, that doesn't sound reasonable to me, and as a result, I'm suing you, okay? So this basically sort of imposes, this does impose a duty to have a written policy and then to comply with that policy. We in the federal government do that. We have what's called the Privacy Act. It's our obligation. Every single record we keep has a disposal plan in place, so it makes sure that we are constantly up to date and getting rid of the data we don't need. What's interesting is, I think with any of these legal regimes we come out, we always end up needing another department within our unit, a compliance department, whose job it is to ensure that we're complying with this. We as lawyers tell them what they have to do, and then we need somebody to go back through and comply with it. But that brings up an interesting point, which is we always have to ensure that our employees are informed, are educated, and realize what restrictions we have on our policies. What I thought was fascinating about this particular thing was that not only do you have to, or say, you only have to have it, you don't actually have to publish it. And so my thought was, well, if I have to publish it, if I didn't have to publish it, well, then what good is it, right? I just have it, I guess. And so I think there's a question of whether or not I could actually go out and ask specifically, hey, can I see your data destruction policy? Because if we go back to the Ashley Madison, if you remember the Ashley Madison sort of hack, when people went in and looked at Ashley Madison records, they found that people who had not touched Ashley Madison for years still had records there, and Ashley Madison sort of shrugged and said, hey, we didn't know if they were going to come back or not. And a lot of the states looked at this and said, wait a minute, we have to do a better job of having a destruction policy in place for every single one. So if you're a covered entity, you need to have one in place. Do we have a standard? It has to be reasonable or not? No, but I think it's hooked right here, right? If this is not reasonable, I'm going to sue you under the first prong, okay? Now, what's the consequence if you violate it? Well, the Attorney General can sue you, can bring suit against you for violating this. It doesn't have statutory damages. It just says that they can bring suit against you, and so what the damages are probably are what damage you actually cause. All right. So that's the first source, the state-specific laws. That's Colorado's. Keep in mind you have other states if you operate in other states and deal with other residents' information. The second source is one that many people don't realize, but the FTC. So when we think about the federal government and the federal government's obligation to protect its citizens, there are two entities that come to mind when we think about cybersecurity. The first one is the FCC, the Federal Communications Commission, which its job is usually to regulate cable and telephones. And then we also have the FTC. Neither one of them have ever been granted official authority to regulate the internet or cybersecurity, as in Congress has never delegated that duty to them. You might say, well, what about this open internet stuff? Well, the FCC does have a tangential authority, Section 706. I don't think that really locks in, but that's a topic for another day. In any event, they cannot regulate cybersecurity. Okay? There's no question that doesn't fall within their powers. But the FTC, on the other hand, has a very broad power to protect or to enforce unfair or deceptive acts or practices affecting commerce that are declared unlawful. What do I mean by an unfair practice? That's one that causes substantial injury or not reasonably avoidable by consumers and not outweighed by countervailing benefits to consumers or to competition. So once again, we have another balancing test, right? We say, hey, listen, the FTC is going to come after you for unfair practices, and those are unfair if they could potentially cause a substantial injury to a consumer, the consumer can't avoid it, and they're not outweighed by other benefits. So for example, if I potentially had a lower cybersecurity to authorize to allow people to have quick access to certain files, maybe that's a countervailing or benefit to the consumers or to competition. So as a result, they would say, no, that's fine, not unfair. Now, how does this apply to cybersecurity? Well, as you can see, the FTC is really consumer-focused. They're really focused on how's the consumer doing. So what if I were to say, collect information? You come to me, you buy something from me, I collect your credit card information, I collect your address, I collect your name, I collect certain other information on you because I think it's extremely valuable because I'm going to market to you later. And then I have really, really bad cybersecurity. Is that an unfair or deceptive practice? So the court tried this, or the FTC tried this. In the FTC versus Wyndham case, you guys know Wyndham Hotels? So way back in the 2000s, early 2000s, people were going, they were collecting credit card information, they were collecting information on their guests. People had to give this information to Wyndham to stay there. So the consumers couldn't avoid it. They had to do that. And then we found out that guess what? Wyndham had horrible cybersecurity, as in never changed the admin passwords. The username was admin, the password was password. And they had a huge breach across all their customers for about 5 years. And the question was, that seems unfair because you're going to cause substantial injury against our consumers, and we don't think that you not changing the password had a benefit to consumers or to competition. And so what was the response from Wyndham? FTC, you don't have the power to regulate cybersecurity. Get out of our chili. The response was, the court said, yes, we do. FTC, you do have the power to regulate cybersecurity if they consider it to be an unfair practice, which means now that if you collect information on consumers and you don't give them a choice, they have to do it to do business with you, and you don't store it and keep it secure, it could potentially be an unfair or deceptive practice. But we also have an example of deceptive practices. If you guys remember Snapchat, is anybody here familiar with Snapchat? So Snapchat's this idea used by all my cadets. I don't get it. But you take a picture of yourself and you send it off when you're chatting with them. And it disappears after a certain amount of time. You can set that. Well, so the idea is that you take these pictures and they're sort of ephemeral. They disappear after a certain amount of time. Everything's great. Well, and so this is a common sexting tool that they use. I'm not trying to frown on that. I'm just saying that's what happens. So in any event, so they use this thing, and Snapchat prided itself on saying, hey, listen, when you take a picture, within 10 seconds it disappears. It's gone. And no one can actually snap this photo of you and keep it. And if they do keep it, by God, we will tell you they kept it, right? We're that good. Well, it turns out they're not that good. These images were not being destroyed. They were actually keeping them for 2 to 3 years at times. That there were all these security loopholes that people could do, right? They could screenshot it, it wouldn't tell them that. They could find ways to access it outside of the program, the sandbox. They would store videos in a different a different place than the actual program, and as a result, all these things were subject to potential exploitation by individuals. So the FTC went after them. And asked Snapchat, didn't even file suit, didn't even try to go after it, didn't even try to contest it, just said, you're right, we'll fix it. Now there's a benefit to that, because did you guys ever hear about this? Nope, right? So they were smart, and they said, we're going to fix it for you. And this long 25-page opinion or so, they explain exactly what Snapchat must do. But at the end, they basically said, we think that's deceptive. You told people you had certain security protocols, and you didn't. And we think that's deceptive to consumers, false advertising, and as a result, we're going to hold you liable under the FTC's consumer trade or consumer protection powers. So that's deceptive. So what's the duty? What do we take from this? Well, the first one is probably obvious. Do not unreasonably necessarily expose consumers' personal data to unauthorized access and theft, which means change your passwords, okay? Not only change your passwords, but you might want to change them regularly, like once every 90 days, okay? You might want to change them on occasion. In addition, I had my wife works in a local area. She happened to work for a small business, and that individual had the same password for every computer, including the administrator password, or administrator's computer. So as a result, all you had to know was one password. It wasn't complex. It was the name of the business. And I would argue that doesn't comply with this particular provision. The second one is don't falsely advertise your security measures. Don't tell people you do certain things when you don't. Just do them, okay? Nothing wrong with that, right? All right, and what's the cause, what's the potential result if you violate? Well, the FTC can bring an enforcement action. Now, it's interesting is the FTC usually doesn't have a fine sort of power, a power to fine you in the event that you screw up. What they normally do is they create an order that hooks you in by saying, if you violate this in the future, we will fine you. And so that's normally what they do. And so maybe the first time you almost get like the one bite free rule, right? Which is, that's a principle in dogs, right? When dogs bite somebody else, you get a principle one bite free, right? And we're not going to prosecute you because you didn't know the dog was dangerous. Once the dog does it, then we know the dog's dangerous. Same kind of concept here. You can potentially violate the first time. After that, we'll probably fine you pretty substantially. All right, the third source goes to what this gentleman over here was talking about, which is certain industries have laws that you have to comply with. Now, I'm not going to go through all of these in much detail because, one, we don't have time, and two, I don't know how much this applies to you guys. But generally speaking, you have financial institutions have the Graham-Leach-Bliley Act, which is what he was referring to, destruction of certain things, certain data protection that you have to comply with through the SEC. The second is healthcare. If you deal with any kind of healthcare, you've got HIPAA. We probably all know what those are, and who you can share information with and who you can't, and when you have to destroy data. And attorneys have their own obligations under the professional rules of conduct. These are all the three industry-specific I could find. There might be more out there, but I don't know of them. I've done some research on this, and so I'm pretty confident these are the only three. But if there's another one out there, if you're specific, he's saying no, this is great. So I doubt there's any others. So the fourth source, and the one that I think tends to not get a ton of particular attention, is litigation. Right? People can always sue you. Okay? And the most common way they're going to sue you is probably through negligence. So you failed, if we define negligence, failure to act as a reasonable person would in same or similar circumstances. When we deal with professional negligence, we technically call that malpractice. So usually, if you fail to act as a normal professional would in same or similar circumstances, we are going to say that you were negligent. So thinking about that, if you are a business person and you have a cybersecurity duty, we might say, well, you have an obligation to act as a reasonable cybersecurity person would or a reasonable business owner would in the practice of cybersecurity. And so we would argue that if you let that breach or if you fail to live up to these standards we've already articulated, we would probably say that's professional negligence or that's malpractice or just simply negligence. So what factors would we consider? Like, how would a jury go about deciding this? If I was to sue you, a jury would be given the decision of, did they act as a reasonable person would in same or similar circumstances? What factors do we think? Well, we don't have a court that's ever actually litigated this. We don't know necessarily when it comes to cybersecurity. But I would say probably just like any other malpractice area, we'd probably look at experts in the field, people who know certain things, right? Certain experts who can say, no, I'm a cybersecurity professional, and this is not adequate, right? Not changing your password or leaving it as password is probably not good. You having the same password for years, the name of the business is probably not good, okay? So that's probably the place we'd look. We'd look at the industry practice. If there are industry standards, we'd probably go look at those. We might look at the size of the business. We do that balancing test of benefits versus detriments, and ultimately conclude whether or not we think you were you committed malpractice or negligent. So I say your standard is failure to act as a reasonable cybersecurity professional would in same or similar circumstances. We also have a potential cause of action for negligent misrepresentation. This is a lot like Snapchat, right? I say I have I'm going to represent to you what our practices are, and if I fail to live up to those, we say that's negligence, right? We say it's negligent misrepresentation. It's a false statement of fact that that causes somebody to get into a contract, and so if you're negligent in those statements, right? I don't know what our cybersecurity is like, but I'm pretty sure it's good. That would be negligent misrepresentation, right? So this is common if you overstate your security, if you were to say, oh no, we're amazing. We are the best security in the world. We never have problems, right? We've never been hacked. You just don't know it yet. Oh, it's amazing, right? You're never gonna have to worry about your information. The one other thing I think is funny about this, if we talk about, do you guys remember the LifeLock? You know, the guy with the LifeLock? And he puts his social security number on a billboard. He's like, I'll never get hacked, right? He's been hacked like over 30 times, like his identity has been stolen numerous times. That's probably, at the very least, negligent misrepresentation, if not fraudulent misrepresentation. And then we have breach of contract. So if you have terms of service within your company and you say, hey, if you do business with us, here's what we're going to do with your information, and you ultimately don't protect it appropriately and you have some standard within your contract, we could potentially sue you for breach of contract. So you probably want to keep those terms maybe a bit amorphous to give you a little bit of wiggle room. And if you violate, well, you could get a jury verdict for compensatory damages, as in they could potentially sue you. If you're grossly negligent, as in we think you've gone really far over the line, you could potentially get punitive damages. Those are the rewards that you hear that are like astronomical, like $200 million or something like that. Those are usually considered punitive damages. Compensatory are those ones that you actually have a damage, a bill you can point to, or some kind of like emotional distress. Those are usually lower. If you mess up and you're grossly negligent, I would say Wyndham's case, not changing the password, is probably gross negligence, and as a result, I think they could have qualified for punitive damages. Do you have a question? No? It was kind of raised. I don't know. All right, so what's the bottom line? So this is just my opinion. This is what I tell people is, I think if you have reasonable cybersecurity practices and procedures based on the information nature inside your business, you're probably fine. How do you get that? Well, you should probably go consult with somebody who's a cybersecurity professional who can tell you a little bit more about the business and how to go about doing things. And then if you contract with a third party, ensure that they are complying, but always consider indemnification in the event they don't. Okay? So that takes care of your duty to keep data secure. I think the reasonable standard is the way to go, and to consult with people. The second duty is what happens when a breach occurs? What should I do? Well, as I mentioned, all states have one of these. Colorado has a new one. They slightly tweaked it. Effective September 1st still, you have to be a covered entity. And here's the two-step process. When you are alerted that a potential breach has occurred, you must conduct an investigation of some sort. You're obligated to conduct an investigation. A prompt investigation to determine whether there's a likelihood that personal information has been or will be misused. What's great about this is it's got this caveat there, right? Which makes you think, oh great, so if it's not likely that information is going to be used, awesome. I don't have to notify anybody. I get to save some face. But if it is likely that it's been used or likely going to be used, notification is required. What's interesting about this is if you are a conservative individual and you're thinking to yourself, is it possible, which do you think you'd go with? Yeah, we probably assume it's going to be misused. Because in the event that we don't, we have to go to now a jury who's going to tell us, or the Attorney General who's going to tell us whether or not we were reasonable in that sort of conclusion that it wasn't going to be misused. And then the second step is if in the event you think that it's going to be misused or has been misused, you have to go through a notification procedure, which is regulated both timing and content. So, timing. As expedient as possible is the way they say it, with no unreasonable delay, but always less than 30 days, within 30 days of the notification of the breach, which means you have to do research, you have to investigate, you have to make this determination, and then you have to do it without unreasonable delay within 30 days. Now, it does say, there's a caveat there that says you're allowed to consider needs of law enforcement, to consider needs of the integrity of the system, and determine the scope of how big this was. So in other words, if you find out and you're like, oh no, that's all the credit card information clearly going to be misused, you don't have to come out the next day. You could say to law enforcement, hey, I'm going to give you information. I don't want to publish this yet because then the individual who hacked knows that we're onto them and will potentially leave. I'm going to give you information so you can do an investigation and potentially bust this individual. And so we might give you some leeway, right? I think we might. I think the court gives you some leeway, the Attorney General gives you some leeway to say, wait a minute, law enforcement needs. I want to give them 5 days lead time to try to figure out who did this so I could potentially go after them. And then the content has to be specific, right? We have to have, you have to tell them the date of the breach or the range of the breach, the information that was acquired, the contact info for the covered entity. So how do you reach out to me? How do you reach out to the FTC? How do you reach out to consumer reporting agencies? A statement of that consumer contain information on what to do about this. And finally, information specific, so info specific notifications. If they were to violate a different statute, you'd have to provide that. And if it's over 500 or more residents, you have to notify the Attorney General as well, which means that you can't hide from a potential lawsuit from the Attorney General. You have to go out and tell them, hey, by the way, this happened. All right. Interestingly, recently we had, you might have read this, the DoD just recently had a breach of travel records. It just so happens that my records were part of that, so I got the wonderful breach notification of all my information, including my passport and my government ID. So, awesome.
How did you get notified?
Email. It's really great. And now it was the travel agency that we used to book all of our travel. So we've switched that, and now we're with a different company that was not prepared for us because they terminated it so quickly. So it's been a bit rough, and I happen to be the travel guy, so I have to prove all these things. It's just a kind of a nightmare. This wasn't meant to be like a psychology thing, but I appreciate it nonetheless. And as a violation, the Attorney General can bring suit, right? So, second source when the breach occurs, once again, the Federal Trade Commission can come after you. So unfair. If you fail to notify these consumers of a breach, right, this is something they have no control over. And if it doesn't match up with, remember we balance that with the sort of benefits to the consumer as well as competition, you're probably not going to meet that in the event that you failed to notify individuals of a breach. So deceptive, don't falsely advertise your notification procedures. Don't tell them, hey, as soon as we find out, we'll let you know in 24 hours, and then it takes you 55 months. So that's an example of where the FTC could potentially come out and do something, and if they violate it, they'll bring an enforcement action against you. We haven't seen any cases on this yet. We haven't seen a case where somebody failed to notify of a breach in a quick time or a reasonable time, and as a result, have to be prosecuted by the FTC or enforced in the FTC. But I think it's only a matter of time. Okay, the third source, again, industry-specific stuff. Not going to go a ton into detail here just because they have their own breach requirements. And then finally, litigation, same ones that apply before. Are you negligent representation, breach of contract, and the violation would be a jury verdict. Right? So same kind of concept, bottom line. If you have a breach, you should probably notify all those affected as soon as possible within 30 days, unless you have other concerns and you can articulate those other concerns in the event that something comes up in the future. Okay, and somebody tries to sue you. If you do this, you will probably comply with almost all the requirements. If you're unsure whether or not it's going to be misused, it's probably better to notify. Okay. Now, I bring up cybercrimes as our third duty. I bring up cybercrimes for two purposes. The first purpose is because I believe that if you are hacked, you probably want to know what your recourse is, as in, what can I do about this? And so cybercrimes is the way to go about it, at least the first one, the anti-hacking laws. And then the other thing is electronic surveillance laws. You might have heard about the Stored Communications Act or the Wiretap Act. Either one of those somewhat hamper your abilities. This is a little bit more important for cybersecurity professionals, but I think it's important to talk about you just so you're aware of them in the future. So the Computer Fraud and Abuse Act, that's the anti-hacking one, the CFAA as we call it, passed in 1986 as a response to war games. Pretty much everything in the computer world was passed in a response to war games, the movie. And so as a result, they came out with this idea. Most states have also codified a version of the CFAA. And so Colorado does, and it's similar to the federal one. If it basically prevents the unauthorized access or exceeding authorized access to gain information, to commit fraud, or to cause damage or loss. Notice you have to have, in the federal rules, you have to have over $5,000 worth of damage when it's a fraud. If it's less than $5,000, it doesn't qualify as a crime under the federal rule. Under the Colorado law, it does qualify as a law or as a crime. It just varies in whether that's a misdemeanor or a felony. Okay, the larger the amount, the closer you are to felony. I think the cutoff is around $1,000 and then it becomes a felony. So in the event somebody does authorize your information and you haven't given them access, or better yet, an employee of yours knows the passwords and you tell them not to access it and they go out and access it anyway, they could potentially be liable or guilty of a crime under the CFAA. Interestingly, the federal one, not the Colorado one, comes with a civil cause of action, which means that if they have damage of over $5,000, you can actually sue them in court for those damages, which means you have to, if you catch them, so keep in mind this process, right? So you've done all your data security possible, reasonable methods, and then you couple that with, in the event a breach occurs, you've notified everybody, and then you finally alert law enforcement. Law enforcement goes out and finds them, they prosecute them, find them guilty, then you can file a lawsuit against them to potentially collect any damages as a result, as long as it's over $5,000 a year. Electronic surveillance laws, so we talked about the Wiretap Act. It prohibits the interception of any aural, which is having to do with the ear, so anything you can hear. So for example, right here, if somebody were to be recording me right now, that could be a potential violation of the Wiretap Act. Wire or electronic communication being transmitted. Exception is in the course of business. So, for example, if somebody were to put like something on your, let's say, unplug your router and plug in their computer and start receiving all this communication coming out of your office, you would say that is a violation of the Wiretap Act because they are intercepting it while it's being communicated. So this is a violation, prevents people from doing this, hopefully. A lot of this time it comes up with, we have like smart speakers and our smartphones and our smart TVs and our smart fridges and our smart everything. As a result, a lot of people argue that that could potentially be a violation of the Wiretap Act. Other people argue that's part of the consent. If I put it in there, it's consensual. You might have heard about the Alexa. There was a murder going on in a house. Alexa recorded everything that went on. They just didn't use it. And the cops wanted Alexa to tell them what the individual actually said, what was happening during the murder. And the court ultimately authorized that. And then there's the Stored Communications Act, which is what the Alexa really falls under. This basically prevents the release of any wire electronic communication and storage. If it's contents of the information, you're not allowed to release to anybody. If it's records, you're not allowed to release it to the government. You can release it to other people. So, for example, if you have records of individuals who buy things from you regularly, they buy once every month, you could share that with another company as a part of an advertising campaign. But you can't tell them what they bought, because that would be the contents of it, right? Potentially, right? It all depends on that. And then the exception is in the course of business, so same kind of thing. If you are grabbing that stuff as part of your business, you're allowed to go get that stuff out of storage. Well, the reason I bring this up is because the other reason is, hey, don't these crimes potentially prevent data or cybersecurity? Which what I mean by that is, well, if I want to monitor my own network to see if somebody's hacking it, I've got a problem, don't I? I'm potentially violating the Wiretap Act if I'm watching these communications go in. If I go out and try to hack back, right, I go respond to try to shut down that individual from hacking me, somehow prevent them from hacking me in the future, am I not violating the CFAA, right? Am I not exceeding my authorization? So Congress saw this and realized that we're hampering it, and they passed the last one, the Cybersecurity Act of 2015, that basically provides you the authority to monitor, even if it's in violation of the Wiretap Act, allows you to operate defensive measures, which means we can somewhat hack back, although it's very limited. So if you're going to hack back, make sure you know what the limitations are. And finally, you're allowed to share other information with other companies and federal government. The goal of this statute was specifically to create a collaborative environment. What we found was that a lot of companies were getting hacked with the same vulnerabilities over and over again, and we were getting frustrated as a government. How do we possibly help you? And so Homeland Security is in charge of data security. They're in charge of cybersecurity for the internal, right? Cybercom does the external offensive stuff, but internally, it's Homeland Security. Homeland Security was asking, please give us information. We want to help companies. And so this was meant to create this collaborative environment. You can employ certain measures, and then you can share it with us. And we will do our best to help you out. Now, privacy advocates say this is basically handing over the keys to the kingdom to NSA to spy on us. And that's, I don't think, what it's meant to be. It usually just goes to Homeland Security, and it stops there. Trust me, I think NSA has plenty of other tools they want to use. All right, well, great. Well, thank you very much for your time. And if you have any other questions, I'll be here for probably the next, at least 10 minutes. So, okay.